How can you sue someone for something they didn't say? In this video, we're going to make sense of what just happened in the civil lawsuit brought by Gabby Petito's parents against the defendants, Brian Laundrie's parents, and their solicitor, Steven Bertolino, as co-defendant in Florida. If you watched the latest hearing, you may be wondering what just happened. The Petitos and Schmidts, who are the parents of Gabby Petito, made a civil claim for emotional distress against Brian Laundrie's parents, Christopher and Roberta Laundrie. I will refer to them for ease of reference as Gabby's parents and Brian's parents. So when there's no connection to a defendant, such as a contract, you bring a tort claim, and that is the same in England and Wales. Gabby's parents brought a lawsuit against Brian's parents for emotional distress. Now, in a civil claim, if you do nothing after receiving a claim against you, the claimant can get a default judgment, because the particulars of the claim are presumed to be true. If you defend the claim, your case will trigger a directions hearing. A previous judge has already set a date for a hearing. So why this interim hearing? Before I discuss that, let me tell you a bit about this type of claim. So in this claim, to meet the criteria, the claimants must prove that the defendants had a duty to behave reasonably and not behave outrageously, or in an extreme manner likely to cause distress. The defendant breaches a duty by intentionally or recklessly behaving outrageously. And in England and Wales, a claim of distress and inconvenience would mean any injury must be an actual psychiatric injury rather than mere distress and inconvenience. And secondly, the likelihood of such injury should be foreseeable to the defendant. Brian's parents deny their behavior was intentional, reckless, or outrageous. They said nothing, and you cannot be sued for saying nothing. It is the same in England and Wales, though in a civil case the burden of proof is much lower than in a criminal case. In the USA, a successful claim is when the preponderance of evidence is more likely true than not. And in the UK, we say if there's a 51% chance, more likely than not, then on the balance of probabilities, the case will go in favor of the claimant. In the UK, prior to the civil procedure rules, a witness was sent a subpoena. Now a witness is sent a witness summons. It is still issued by the court. If you refuse to show up, this is contempt of court, as you are being compelled to give evidence. So if you're giving testimony in a civil case and you refuse to answer the questions, the judge will decide if you must answer. If the judge decides you cannot rely on a privilege, then you must answer the questions. If you fail to do so, you will be held in contempt of court. The negative outcome is adverse inferences can be drawn, i.e. the burden can be placed on the defendant's side of the litigation fence. So this is different to a criminal case where you have the right to not answer. Though we can also see this in criminal court, where a court is permitted to draw adverse inferences, where a defendant relies on facts in their defense that they did not mention when being questioned under caution or charge. Though Brian Laundrie's parents said they stayed silent when Gabby Petito went missing on the advice of their attorney and want the court to dismiss the lawsuit against them. So this will just give you a little bit of a history, but in June of 2022, the judge denied Brian Laundrie's parents' motion to dismiss, and then again in January 2023, the judge ruled that Steven Bertolino could be added as a co-defendant. He was Brian Laundrie's parents' attorney that made the statements, and in this hearing in May 2023, they are both now making applications or motions to dismiss the lawsuit against them. This is probably a good time to note that under Florida law, Brian Laundrie's parents would have been protected under Florida statute 777.03, which states a spouse, parent, grandparent, brother, sister, or person related by blood or marriage to a principal actor cannot be charged with aiding and abetting. And I thought surely if they knew where he was, they were perverting the course of justice. I've done a video on this, which I will leave in the description area. Gabby Petito's parents also claim that Brian Laundrie's parents knew that Brian had killed Gabby and they were assisting him to flee the country. So they wanted disclosures of bank statements, and they also wanted Brian's parents to disclose a letter his mother had written to him, famously dubbed Burn After Reading. though Brian Laundrie's mother did not want the burn after reading letter disclosed, saying it was only written when Brian and Gabby left for their cross-country road trip, and it was to let Brian know how much she loved him, as their relationship was strained at the time. So here we are. So at this latest hearing, the court scheduled the 4 motions, and because 2 of the motions were to dismiss, the judge asked the defendants to speak first, as it makes logical sense. If she ruled to dismiss, there'd be no need to hear the other 2 motions by Gabby Petito's parents to disclose the bank statements and burn after reading letter. Bertolino had his own attorney, and after his attorney made arguments, one being that the motion should be dismissed because his client's statements made to the public were not outrageous, as he had a duty to his clients. The judge asked some great questions, like how is he protected by the attorney-client privilege when he is not part of the Florida bar, as the Florida bar gives an attorney no legal obligations to make a public statement. Well, let's hear how the judge decided on this motion.
Assuming you all know that I'm going to reserve on this particular issue before ruling, so that is what I'm going to do on the motions to dismiss, and I hope to have orders out for you all shortly with regard to those. We do have 2 other issues that we need to address.
After the judge decided to reserve her judgment on dismissing the case, there was rebuttal from both defendants' attorneys, pointing out that the claim has not complied with the exact wordings, which are the elements needed to go forward. The judge then said, after hearing this, she might change her mind on that. First was the bank statements, and the judge had reviewed the statements and ruled that there was no amounts withdrawn that would suggest that Brian's parents had withdrawn monies in excess of $10,000 that did not go to anyone else but their attorney. This is the same in England and Wales. You can file evidence only for the judge to review and decide if the evidence should be disclosed or, said differently, shared with the other side. Then next up, the judge, after hearing arguments on the motion for a protective order regarding the burn after reading letter, the judge asked the parties if they wanted an order that the letter be sealed so that it was not disclosed to the public, as a middle ground. However, when Gabby's parents' attorney mentioned parts of the letter in open court, it meant that the letter could be taken out of context, so the defendants agreed to it being disclosed. Let's listen to a part of what the attorneys had to say after court.
Yeah, with letting them use the letter as well, we know that the letter has now been handed over to Mr. Riley. What are your concerns in that aspect?
Well, obviously we were concerned about how the letter might be used, that it could be embarrassing and whatnot. But it's part of the case now. It's part of discovery. And so I'm sure it's something that we will address again as the case progresses.
Will this continue to help with some, not closure completely, but just closing out that chapter?
Well, the whole intent of this is to get answers. There are still many questions that the Petito family has about what the Laundrie family knew, what they did with the knowledge that they knew, and really why they didn't come forward and say anything. I don't know that that question will ever get answered because the court has found had the right not to say anything, but there's a lot of questions that the family would like to have answered before they can get, if you can get closure at all in a situation like this, but at least get some closure.
So we're waiting for the court to rule on if she will dismiss the claims. As of right now, there is a jury trial set for the 14th of August, 2023. Well, I hope you found today's video interesting, and information is power. Why not subscribe and watch more of our videos? If you need legal help, contact Legal Minded Friends.